Now back to the show. This is The Law Show on CL 650.
Papa was a rolling stone. Wherever he laid his hat was his home.
My papa was a rolling stone. Who's your daddy? Is kind of what we're talking about here on The Law Show this morning with John Lakes and John White from North Vancouver's LakesWhyteLLP. They are estate and wills lawyers, and the program today has been absolutely fascinating, particularly as it pertains to, inheriting the law and science. And John White, you told us in very rapid fashion just before we took the break about how here in British Columbia, the new law, the Wills, Estates, Succession Act, or WESA, which is the law governing all the work that you two do. There's now a provision in BC law where a person can be born within a certain specific period of time, well after someone dies, and still be 100% eligible for all the goodies in that person's estate. Walk us back through that one again, if you would, please.
Well, Sterling, this has got to be one of the most interesting provisions in the whole Act, at least as far as I'm concerned. It's always been the law that a child who was conceived before the death of the will maker, but is born what will be up to 9 months later, is entitled to be considered a child of the deceased person.
Sure.
That goes back to the Middle Ages.
Right.
What's different in WESA is the introduction of the use of human reproductive material, that is, frozen embryos, frozen sperm, or however one preserves sperm. And there's lots of it out there. And what the people who wrote WESA have done is to say that if you are married to or in a marriage-like relationship, a common law spouse, of someone who dies and you're in possession of human reproductive material, you can use that material after the will maker has died and create a child who will be considered a child of the dead person. Even though death happens first, conception happens second through the assistance of science,
right,
and you still have a child of the deceased. There's a couple of rules, I guess, ground rules for this. Number one, the person using the material has to be married to or in a marriage-like relationship with the deceased person.
Okay.
So once you get past that, such a person needs to give written notice within 180 days from the issue of what we call a representation grant, usually a grant of probate.
So this is sometime after the person dies.
Right.
So within 6 months, what do you have to do?
And 6 months is actually, the Act is quite specific, 180 days. It's not quite 6 months.
Okay.
So you got to count. Got to count the days. But if a person in possession, a spouse, I guess, in possession of this material, gives notice within 180 days from the issue of the representation grant to the executor, to the beneficiaries, and to people who would succeed if there were no will, that they may use this human reproductive material that they've got. So they give note. So far, we got a spouse.
Yep.
We got a 180-day notice.
Yep.
Third thing that has to happen is that the child has to be born within 2 years after the deceased dies.
Okay, so that's the timeline. Okay.
Right. And that child has got to live for at least 5 days, but these days most children do. If you have all of those elements, then the child conceived up to 2 years after death of the deceased nevertheless gets to be a child of the deceased.
A perfectly legal descendant.
Absolutely.
Wow.
And there is power vested in the court to extend even that timeline if the court considers it to be appropriate on all of the evidence. So there's a huge amount of wiggle room on top of those timelines.
And John Lakes, this assumes, of course, that all is clear and mapped out straight ahead. There's no dispute over the ownership of the reproductive material, unlike that celebrity thing we were talking about a few minutes ago.
No, I think that's true, but the problem is it does create a problem for the rest of the estate, because then the estate may be frozen for 2 years, and there may be
awaiting the birth of this child.
And there may be children that are under the age of 19 that need money for university or something, and so it may mean that if you're acting for the executor, you may have to go to court and say, what am I supposed to do? Because if the executor makes decisions that might affect somebody that doesn't even exist yet, they will need a court to assist them, because they don't want to all of a sudden be personally liable for bad decisions they made. In the meantime, they don't want to deny the children from the first marriage the right to go to university or whatever. So there hasn't been any cases on this yet.
Right.
And the first lawyer gets this case is going to be really excited because it's going to set new law. And the judge that will do it will be quite exciting too. But it's just, and right now DNA, it can just come from sperm or women's eggs. But maybe 20 years from now, it might be your hair or your skin sample.
Sure.
So it's like, and I don't think legally we're prepared for these changes.
Well, as I sit here and listen to this explanation, just of this one very tiny element of the wills and estates law, it strikes me that the civilian who is nominated or requested to be the executor in this matter is all of a sudden going, oh my gosh, what have I just gotten myself into? We're fresh out of time, guys. But when we come back next time, can we talk a little bit about executors, about some person who agrees, perhaps over a couple of drinks, to be, I'll be your executor. Sure, what the heck? We've known each other for years. And you say, fine. And you don't think about it. All of a sudden, you're an executor. Now what? Can we spend some time on that down the road?
Yeah,
we were
looking forward to that.
We were thinking of another topic for the next one.
Oh, no problem. No problem. We'll just include a little advice for executors, because I'll bet you, as wills and estate lawyers, you get more than the odd call from a person going, I'm an executor now, so now what? Help. You get a lot of that?
They say, help, help, help.
John Lakes and John White, LakesWhyteLLP in North Vancouver. Great show, guys. Lots of fun. Great information. Looking forward to the next one already. See you next time, friends, right here on The Law Show.